Welcome to the third podcast of Module 7. Uh, this relates to remedies of a mortgagee upon the default of a mortgagor, and of course refers primarily to torrent system land, as with the other parts. You can see from this slide that we are going to be looking at a number of different remedies, but the most important that we will be looking at is the most common, and that is the exercise of power of sale. This is by far the most common form of remedy and operates only in respect of registered torrent system mortgages. However, for the sake of completeness, we will look at all the other remedies and options open to the mortgagee upon default by the mortgagor. The first is the most obvious, really, and that is an action for debt on the personal covenant to repay. Obviously, the mortgage is a contract by the mortgagor or the borrower to pay the mortgagee both the principal and interest owing over the time period of the mortgage. By far, the most common personal covenants are contained in written mortgage documents. If there was no written mortgage document with a personal covenant to repay, there would be one implied in relation to land under section 78(1)(a) of the Property Law Act. However, given the prevalence of mortgages in writing and in proper form, this implied covenant would be rarely used. The personal remedy is only really compared to the right to collect a debt under an agreement for loan. It does not affect the mortgage property itself, and in that respect is rarely used. Almost invariably, if money is owing, that is principal and interest is owing under the mortgage, a mortgagee will take steps to exercise a power of sale and hope that the mortgagor pays both the principal and interest up to date before action has to be taken to sell. And in that respect, if you see on the slide, the debt has to be fully repaid or action can be taken to sell. One final thing to note is that a mortgage, once registered on the title, takes effect as a deed, and the right to sue under a deed is called a specialty debt, and the period of limitation for collection of a specialty debt is 12 years after the money becomes payable. This is different from money payable under an ordinary contract of loan, as the limitation period there would be 6 years from the date the money became payable. The second remedy, which is more often used than the first, being the collection of the debt, is entry into possession of the mortgaged property. In every mortgage in writing, and you see the note at the top there, clause 8(1) is the relevant clause in the mortgage on the CMD, a mortgagee may take possession either actually by taking physical possession, or where the mortgage land is leased by taking constructive possession by entering into receipt of the rents and profits of the mortgaged property. You will recall that where a lease is entered into after a mortgage has been registered, subsequent to the mortgage, the mortgagee must give consent to that lease. If there is no consent and the property is mortgaged, there is obviously a conflict between a mortgagee who wishes to enter into possession and a lessee in possession. So in the document, which is a deed of consent to lease, the mortgagee will seek a direct line to the tenant in that document. In the case where the mortgagor, the borrower, might default, the mortgagee can look directly to the tenant to claim rent and thus use that to discharge the mortgage. Of course, a mortgagee might exercise power of sale without any formal entry into possession, and this is most commonly the case. In the exercise of power of sale, a mortgagee will want to sell with vacant possession because that's what a buyer of the property will want. So in that case, a mortgagee might be seeking vacant possession, that is to remove the mortgagor from the property if they want to sell. But simply seeking vacant possession may not be equated necessarily with taking actual possession, in the sense that the mortgagee, to exercise power of sale, does not actually have to physically enter possession nor receive rents and profits from the mortgaged property. Thus, the right to enter into possession is normally in the mortgage document itself, or it's implied. But as I said, it is really implied. In the case of entry into possession, a mortgagee is subject to certain duties. If the mortgagee enters into possession by receiving rents and profits, or by running a business on the property, which it would be entitled to do under the mortgage instrument, then it has a duty to account to the mortgagor for the money it receives as a result. Of course, this money must be put towards the repayment of the mortgage. And once the mortgage is repaid, the mortgagee has no further right to be in possession. Secondly, a mortgagee in possession may be liable to account to the mortgagor for damage to the property which is deliberately caused or caused by negligence in the use of the property by the mortgagee. And thirdly, a mortgagee in possession may be liable to certain statutory outgoings. For example, the payment of rates and land tax or body corporate charges. These, of course, may be added to the amount owing under the mortgage itself. And to that end, really, a mortgagee, except in unusual circumstances, will probably not enter into possession, but would do the same thing through a receiver, which we'll look at shortly. Finally, I should mention that a mortgagee wishing to take possession should give written notice to the mortgagor in the property by way of demand for possession before issuing ejectment proceedings in a court. I just mentioned the appointment of a receiver. This is usually expressed in a document and can be accomplished on default. The receiver is an agent of the mortgagor, and therefore the mortgagee is not liable for acts of default of the receiver. This is the preferable way to go, rather than a mortgagee entering into possession when they may be liable for their own acts of negligence and liable to account. Thus, receiverships are relatively common and more common than mortgagees entering into possession. There is a power in every mortgage document to do so. It is a very common power expressed, or it might be implied unusually under Section 83(1)(c) of the Property Law Act. The fourth remedy, again, which is not common, is the remedy of foreclosure. The concept of foreclosure comes from old system land. You will recall under old system land, non-Torrens land, that a mortgage took effect as an absolute transfer of the fee simple to the mortgagee, with the mortgagor being able to exercise the right to recover the property or the security by way of a suit for equity of redemption. So under the old system, if the mortgagor fell into default, the mortgagor would run the risk of having the mortgagee simply declaring itself to be the absolute owner of the secured property, and in that event, the mortgagor lost the right of equity of redemption. The power to foreclose is still retained in the Queensland Torrens legislation in the section mentioned. Where the mortgage is a charge and the mortgagee is really a chargee and not have any right to possession except on default under the mortgage that we've just spoken about, and the mortgagee wishes to foreclose, there are a number of steps that the mortgagee must take. The process of foreclosure in Queensland requires an application to the Supreme Court, whereas it does not under other jurisdictions in Australia, where it can be simply done through an application to the Registrar of Titles. But in Queensland, what happens is that the mortgagee applies for an order for foreclosure and is given what's called an order NISI, N-I-S-I, and that order really says an account of the amount owing is taken. A mortgagor is then given a reasonable time to pay that amount. It may be 3 months, it may be up to 6 months. And if the mortgagor has not made the payment due within that time, a second application to the court is made to report this fact, and the court will make an order absolute for foreclosure. Once the order absolute has been made, a vesting order is sought and the land is then vested in the mortgagee absolutely. Now, this type of action really means that the mortgagee ultimately, through this process, becomes the absolute owner of the property. It is not a clog on the equity of redemption, but it is a process by which the court makes the order and the vesting order is registered in the Titles Office. Once it is registered, the mortgagee is an owner, free of any interest of the mortgagor. The debt of the mortgagor is extinguished. So if you look at this chart, you will see that the effects of foreclosure are simple. Mortgagee becomes the owner, mortgagor loses the right to redeem upon that vesting order being made. The charge over the land is effectively released. Obviously, if the mortgagee becomes the owner, there's no point in the charge. The debt is extinguished. This is quite important. The debt is extinguished completely. It means the mortgagee can no longer claim any money from the mortgagor, regardless of the value of the security at the time of the order. And the personal covenants in the mortgage are completely extinguished. Now, you may recall that in the case of the GFC and prime mortgages in the United States, banks commonly foreclosed on properties. And in the end, what it meant was simply the mortgagor could not pay the loan, and they simply took their keys into the bank and said, it's your property, and the bank simply took steps to foreclose. In America, in most jurisdictions, it was not necessary to go to the court. And then, of course, the property became the property of the bank. The most common remedy is that of the exercise of power of sale. Under the old system, it was common in the late 19th century for there to be a clause in a mortgage to allow a mortgagee, upon default of the mortgagor, to exercise a contractual power of sale. This power of sale was regulated by a court of equity to make sure that the mortgagee did not act in fraud of the power. That is, sell the property for reasons other than the continuing default of the mortgagor. This later became a very common remedy and is now encapsulated, or has been for some time, in statutes and is really in every written real estate mortgage in the country. You can see here from this slide how it works. The loan amount is $450,000, the purchase price $500,000. Mortgagee exercises power of sale. It gets a certain price for the property. It takes what is owed under the mortgage, and the mortgagor is entitled to the surplus. It is the mortgagee who operates the whole process, advertises the land, etc., as we will see, deals with the real estate agent, and acts in the same position as if the mortgagor was selling in the normal course. This is a quick and easy way, but it requires some steps for this to occur in the case of registered land. So, as I said, the source of power can be in the document itself. Look at clause 8.1a of the CMD mortgage, or could be implied, which is very rare. What are the preconditions to exercise the power? Firstly, and obviously, default. Secondly, the service of a notice in Form 4 of the Property Law Act under Section 84 of that Act. And thirdly, the continuation of the default for 30 days. It means that if a mortgagor makes good the default within the 30 days, the power of sale lapses and the mortgagee has no other recourse. What, therefore, are the preconditions of the exercise of power of sale? Well, I mentioned for Section 84. Section 84, if you have a look at the forms in the Property Law Act, is not mandatory, but everyone uses it because it contains the exact type of information that is necessary to accompany the form for it to be valid. It must be in writing, etc. It requires the default to be rectified within 30 clear days from service, not the date of the notice. So the notice might issue, but it might take a week to serve the notice on the mortgagor, and the notice must be served according to the mortgage document itself, or subject to Section 347 of the Property Law Act, where there is no notice provision in the mortgage. So a mortgagor is given 30 clear days to make the payment. And any time after that 30 clear days, the property must be sold. As we shall see, once a contract is entered into with a third party, the mortgagor loses the right to redeem the mortgage. At any time up until that period, even during the currency of the notice, a mortgagor may exercise the right to redeem by tendering the amount owing. Now, there are cases where there are errors in the Section 84 notice. And obviously, if it's substantial or the mortgagor is misled, the notice will... It is quite critical that the notice be as correct as possible. Obviously, minor errors are not going to affect it. But for example, if the notice says to the mortgagor, you owe $100,000 to make good the default, and the amount owing is only $50,000, then the mortgagor is going to get the wrong idea in what is required to do so. And of course, it is unfair. Such a notice would be completely misleading and would be invalid. And if the mortgagee still wished to exercise power of sale, the mortgagee would have to start again with a fresh and correct notice. The court will look at whether the notice is misleading in that sense. As I said, a minor mistake will not necessarily invalidate the notice. It is the whole of the notice that the court looks at and draws an inference as to whether it is too misleading to stand. And you might note here that a purchaser from a mortgagee is not bound to inquire into the validity of the notice or the process by which it was served. So if the notice is wrong and a purchaser purchases the property, a purchaser does not have to be concerned about it being wrong. If it's discovered that it's wrong before a purchaser enters a contract to buy the property, then it can be rendered invalid depending upon the extent of which it is incorrect. We'll look at this a little later. Now, a mortgagee, when exercising the power of sale, has a duty which is in statute in Queensland under Section 85 of the Property Law Act, in the case of non-residential mortgages, and Section 85(1) capital A in the case of residential land, which would include land with a house on it. Section 85 and 85(1) state that a mortgagee has a duty to take reasonable care to ensure the property is sold at market value. Now, at first glance, this appears to say that a mortgagee should not be negligent in ensuring the property gets market value on sale. At common law, the duty used to be twofold. One, to act in good faith, that is, not to willfully and recklessly sacrifice the interests of the mortgagor, and two, secondly, to take reasonable care to obtain the best possible price. In Section 85 and Section 85(1)(a, the duties have been subsumed, and the remedy for breach for both these matters is limited to damages. So there are cases which we will see which are on the borderline between bad faith and fraud. And these are the difficult cases. If it's a case of bad faith and the mortgagor suffers loss as a result, the mortgagor in Queensland would only be entitled to damages for that loss, because both the tortious duty, that is to use reasonable care, and the duty to act in good faith is all subsumed under Section 85. The other effect of this is that if the sale has been dodgy for one reason or another, that is sold at a low price, or there may be some issue between why the mortgagee is acting in bad faith, a mortgagor will not be able to seek an injunction to restrain that sale once it's entered into, but will be left to their remedy in damages. This is slightly different from the position in other jurisdictions which do not have Section 85. You can read an account of how these duties are seen together in Cameron and Brisbane Fleet Sales at the pages and paragraphs mentioned. Now, I've said that in the case of residential mortgage sales in Queensland, Section 85(1)(a) is an amplification of the duty in Section 85. In the case of a residential property, there are particular requirements to discharge on the part of a mortgagee to show that the duty to get the best possible price at the time, the proper market value, has been properly discharged. A mortgagee must show these four things: that the property has been adequately advertised, that there's been reliable evidence of the property's value, that if the property is run down, it must be put in a fit condition for sale, and of course the charges are added to the mortgage amount owing, and the property should be sold at auction if at all possible. In fact, most mortgagees exercising power of sale sell at auction. Now, these are the same elements in a sense which would show a discharge of the duty for the sale of non-residential properties, although in Section 85(1)(a, in the case of residential mortgages, they are explicit in the statute. Let's have a look more carefully at some of these duties. A very important duty is to advertise adequately. That means advertise a reasonable time prior to the sale, and in such a way as it could be seen by as many potential purchasers as possible. Now, Makina Maloney, of course, was a case where the property was in Proserpine, but only advertised in Mackay. The valuation of the property was found to be $62,000, and the sale price ended up at $50,000. The court found that this was a breach of one of the duties of the mortgagee to properly advertise the property. In the instance of advertising now, most advertising for real property is done on the internet. So to properly discharge this duty, a mortgagee would have to advertise on a commonly used market website, for example, domain.com or realestate.com, to maximise the opportunity of those persons looking for property in that area to see that the property was available for sale. So the cases mainly deal with advertising in newspapers, but the reality now is that would be really looked at in terms of advertising on the internet, where most buyers would be looking. The idea, of course, is to get as many people as possible to a public auction. One of the other duties is for the mortgagee to properly fix the reserve price. A mortgagee not owning the property or living in it would have very little idea of the reserve price. That is, the minimum price which is reasonable to sell the property. And therefore, to do that, a mortgagee will normally obtain a valuation from a valuer, and sometimes two valuations, to protect themselves so that they can inform an auctioneer exactly what reserve should be put on the property. An auctioneer is going to ask them what the reserve is, and it is the mortgagee who sets that reserve and advises the auctioneer. It should be noted that just because the property does not sell at the valuation, it doesn't automatically mean that there's been a breach of the duty to exercise care, reasonable care in selling. However, if a mortgagee fails to seek information about the reserve price from an expert who might know, a valuer or real estate agent, then they may have breached the duty if the mortgagee later complains that the property was sold at a loss. So the duty might be stated very simply, and this comes from Cameron Brisbane Fleet Sales at the paragraph indicated. The duty goes beyond merely seeking a valuation. The duty includes the mortgagee considering the valuation and understanding what it means in relation to the setting of the price. As I said before, this is because merely selling below the valuation is not by itself necessarily a breach of duty. It depends on how far below the valuation and whether the mortgagee during an auction should have simply asked for the property to be passed in and an auction re-held when a more realistic price might have been offered, one which was closer to the valuation. Well, what does Bangadilly tell us? Obviously, the sale must be independent and not made in bad faith. But because the sale was set aside, it really meant that if the purchaser, if this was in Queensland, it wasn't, it was in New South Wales, but if it was in modern day Queensland, the remedy of damages would not be sufficient. Here, because of the relationship between the mortgagee exercising power of sale and the purchaser, would have meant that the sale would be set aside, as the High Court suggested, but looked at another way, it would have meant that there were personal equities which would affect the defeasible title of the purchaser. So the purchaser would not obtain indefeasible title because of the personal equities which arose because of the nature of the sale. Effectively, it is almost tantamount to fraud, because the same result would occur if there was fraud and collusion between the mortgagee exercising power of sale and the purchaser. Section 85(3) speaks of damages. Obviously, the person who loses on a sale at undervalue is the mortgagor, because it really means that there's no money left by way of surplus to pay the mortgagor if a lower price is obtained from the sale. And of course, a signpost for this would be where the sale is exactly for the amount owed under the mortgage. The second person who might miss out is a guarantor, because a guarantor under the mortgage picks up the bill for the amount that the mortgagor cannot pay. And Section 85(3) really protects any person again who suffers loss as a result of the sale. Well, I've mentioned the mortgagor, but of course, if the guarantor has to pick up the gap between the sale and what is owing under the mortgage, they too can sue for damages if the property is sold at an undervalue. And the undervalue is measured, of course, by the difference between the market value and the contract price, which would seem to be obvious. Now, finally, we will look at the anatomy, if you like, of a contract entered into subject to a power of sale. The remedy of an aggrieved mortgagor, apart from Section 85 and the right to set the sale aside, might depend upon the particular point at which the transaction is reached. For instance, if there has been an arm's length sale to a purchaser at undervalue and the purchaser has signed a contract, technically the mortgagor loses their right of redemption, and if the purchaser is honest and there are no equitable claims against them, no collusion with the mortgagee, the contract should proceed. Section 85 suggests that the contract should proceed rather than a purchaser seeking an injunction to restrain it being proceeded with, or entering a caveat which has the same effect. So there's a period before the contract of sale, just after the option. There's a period after the contract but before settlement. There's obviously a period after settlement but before registration, where a mortgagor can obviously show loss, continuing loss, and there's a period after registration. Let's look independently and separately at these particular times. So firstly, as part of the process, there's default by the mortgagor, a notice is served, 30 days elapses. After that 30 days, the mortgagor works out the price, gets a proper valuation, advertises the property, and might accept an offer from a purchaser. An enforceable contract's entered into. Settlement may be 30 days or longer. If the settlement occurs, at settlement the purchaser gets a declaration from the mortgagee of continuing default, which goes into the titles office together with a declaration exhibiting the Form 4 notice that's been served on the mortgagor, so that the Registrar of Titles is aware that the sale is by mortgagee exercising power of sale. It is the mortgagee who signs the transfer, and with these other declarations, as far as the Registrar of Title is concerned, all requirements have been adhered to and the sale is regular. There will be a normal settlement, as with any other property, a lodging of a transfer and supporting documents and registration of that transfer. And normally, of course, certainly once registration occurs, in the absence of fraud or conduct which might amount to in personam exception to indefeasibility, the purchaser will remain registered with indefeasible title. Here is a graphic stating the particular steps to which I've just alluded. If it comes to the mortgagor's attention that there is some vitiating factor in the exercise of the power of sale, either that no case has been made out to exercise the power, and at its worst it'd be that the mortgagor is not in default, or that the notice of exercise of power of sale under Form 4 is invalid, the mortgagor may seek an injunction restraining the exercise of the power. However, as a condition of this injunction, the mortgagor may have to pay money into court. The payment into court is not invariable, particularly if there is a dispute as to the amount owing under the mortgage. The whole idea of the payment into court is as with any injunction. That means an injunction will be given on a balance of probabilities, and upon an undertaking by the plaintiff seeking the injunction as to damages, that is, for any loss that the defendant might suffer as a result of giving the injunction. Now, in Inglis's case, the court examined the objections of the mortgagor to the exercise of the power of sale and found there were wild accusations about fraud, misleading conduct, and defamation, and found that in such a case the injunction might in fact not lie. And if the injunction did lie in relation to Inglis's case, the mortgagor would have to pay the whole of the amount into court, because it appeared that the mortgagor's allegations against the mortgagee would not stand up to scrutiny once evidence was admitted. So in Clark Japan Australia Machines number 2, that's the second case with the same name, the Queensland Court of Appeal has made a statement which is generally correct and seeks to state the rule as to the giving of an injunction. In the case where there is a cogent case against the mortgagee who may have entered into the mortgage through misleading or deceptive conduct or through fraud, it may not be necessary to stop a sale by the payment into court by the mortgagor in order to get their injunction. However, in most other cases, it might be necessary to do so. However, these cases are very rare and are limited to a few matters, as I said: fraud, invalidity, and the lack of the mortgagee's case to seek the remedy of power of sale in any case, obviously because the mortgagor was not in default in the first place. But this would have to be shown clearly by the mortgagor when they sought the injunction. And this slide here, the next slide, does give you a list of those exceptions. But they are not very common. Now, what if an injunction is sought after the contract but before settlement? Here, the likelihood of obtaining an injunction is remote, because if there has been fraud, an injunction will lie and the chances of the contract being set aside will be good. Also, of course, if that's the case, the mortgagor could lodge a caveat under section 122(1) of the Land Title Act as a registered proprietor seeking to protect their interests. And of course, in the absence of that, an injunction would lie. The cheapest way, of course, is to lodge a caveat. But generally, where an injunction would not lie, and where it was merely a case of negligence, that is, failure to discharge the duty to take reasonable care to ensure the property is sold at market value, or a case of bad faith of something less than fraud, then no injunction will generally be granted. The common law case, not a Queensland case, of Forsyth and Blundell in the High Court in 1972 was a case where there was willful and reckless disregard of the mortgagor's interests, reckless indifference to the mortgagor's interest upon a sale. Now, in this case, the court came to the conclusion that the mortgagor had proven this, but without an intention to defraud. In other words, there was no corruption or collusion with the purchaser. The majority gave an injunction in this circumstance, but in Queensland today, with Section 85, which did not exist in the case of Forsyth and Blundell, that injunction would not lie. The sale would be allowed to go ahead, and an action for damages would be permitted at the suit of the mortgagee after the sale. So note the difference between invalidity, fraud, and the others, reckless indifference and negligence. This slide does give you some details of the particular fact situations in Forsyth and Blundell. Where the mortgagor would be successful then, I doubt would be successful in Queensland. The idea of Section 85 really was to prevent the lodgement of caveats by mortgagors in this situation. And don't forget, if you lodge a caveat without reasonable cause, you, the caveator, might be liable to pay compensation for any loss suffered by the caveatee. And secondly, it was to prevent injunctions in those cases which were borderline and where damages would be an adequate remedy. So there's a graph of the situation after settlement. Obviously, if there's been fraud, and the purchaser is not involved, the sale will stand. The mortgagor may get damages if loss can be shown. If the purchaser finds out about some irregularity after contract but before settlement, again, it is unlikely in Queensland that the sale would be set aside and damages would be an adequate remedy. However, if the purchaser is involved as a party to the fraud, which is probably greater than bad faith, and perhaps where the mortgagee is in collusion with the purchaser, the order that the sale will be set aside will be made. The purchaser could lodge a caveat to prevent the purchaser from acting on the transfer if that occurred before registration. After registration, once a buyer is registered in the absence of fraud or an in personam exception, their title would stand. Of course, this would not happen in the case of a collusive buyer where their title would not stand. It would be subject to the restoration of the mortgagor's title, subject to the existing mortgage. So that is what has to be understood, these concepts, in the case of exercise of power of sale. And you should look at those cases that have been mentioned in this podcast. Thank you. That's all for this part.